on another wonderful Thursday, a dry Thursday. Jeez, it's been intense here in Brisbane the last week, let me tell you. But fortunately, we're all above ground and we haven't been washed away just yet. I am Chris Irons from Strata, former Commissioner of Body Corporate Community Management. With me every Thursday, as per always, Frank Higginson. Frank Higginson, partner at Hynes Legal. Frank, welcome.
Hello, Chris. Hello, everyone. Late in the week, mate. And I've gone the cricketing theme with the Ashes coming, so very excited about that.
It's that time of year, isn't it?
It is, isn't it? First day of the first test blues.
Yeah, it's exciting. As per always, well, actually not as per always, a bit of a new feature here. If got a link to provide everybody, which you can get that to you by the end of the webinar, actually. So it's a link to actually automatically remind you about the webinars. So we'll get that to you by the end of the webinar. And also don't forget, if you've got comments doing it live, by all means, chuck up the questions. We'll try and get to as many of those as we can today. But if your question is a little bit more involved, we've got a link for that as well, which we'll put up there in a moment. Today, Frank, tenants. Strata, they've got no rights in Strata, do they?
Well, the perception might be that's the case, but it's actually not, because they're specifically recognised in legislation. And I suppose, probably for me, there has always been this age-old tenants versus owners. You know, we did segregation with vaccination last week, so we might as well continue it. There's always been this difference where people regard themselves in different ways, and probably the prime war story for this is we moved out of our house into a unit for a while. The building manager set up a residence off the plan, brand new, a resident Facebook page, so residents page, not owners, not occupiers. And in the first week, something got stolen from the gym, and someone posted, well, there you go, tenants stealing our stuff again. And then it was World War III. Yeah. So all the tenants saying, what basis do you think that's us? It could easily be an owner occupier, and it just went ballistic. And that's always been there. And I suppose today a bit about correcting some of that misinformation, because tenants absolutely do have rights, and a lot of them.
They certainly do, Frank. I remember when I was commissioner, wouldn't happen all the time, but we'd certainly hear stories about certain strata managers who would say, oh, well, we don't deal with tenants. We don't talk to tenants. They would not take calls from tenants. They wouldn't respond to tenants. And it was our sad duty to inform them. In fact, yes, you must do that. And we're going to explain why today. And one of the reasons why we're doing this today is, I guess, residential tenancies is a timely issue at the moment. I think everybody would know that the market in Queensland is exceptionally tight, particularly in some areas, isn't it, Frank?
Yeah. Oh, mate, it's. I was talking to some of the crew the other day about NRAS units. So NRAS was a Rudd government, however many federal governments ago that might be, response to housing affordability across Australia and the availability of rental accommodation close to CBD areas. So that is 2008-ish, 2009-ish. At that stage, they also then changed what was the Residential Tenancies Act to prevent things like rent bidding, which was, so they created some more affordable housing, put some constraints around landlords and what they could do with respect to demanding rents for properties. And dare I say it, 13 or 14 years later, I think this market's actually harder for tenants to be able to put their foot on a property, I think, than it has been since then, and might be even harder than then. It's extraordinary. Yeah,
I think that's right. So, and look, we're getting to that time of year where perhaps that market will tighten even further. After the 17th of December, allegedly, we're going to see international students back in the country. And so there'll be certain areas of Brisbane in particular that will find themselves under intense pressure for rentals, I would suggest. But not only that, the other prompt for today is that residential tenancies have been the subject of some considerable government reform over quite a few years, but this year in particular. Frank and I have been involved in some of that work. I think at one point I actually got to speak at a parliamentary committee hearing about the residential tenancies legislation. So that legislation has now been passed and it's being made effective in stages. So the first stage is already upon us, and that is reforms about people who are escaping domestic and family violence. And there have been a range of reforms put into place around that, and they are operational now from the 20th of October. We'll get to the main part of that as it relates to Strata in a moment. I think generally, though, Frank, our view is that tenancy legislation and body corporate legislation have always tended to sit a bit uneasily with each other. I think on both sides, there's a lack of understanding about the other.
Yeah, absolutely. And the differing sort of rights and responsibilities. You add that body corporate into the mix with the committee, and I suppose as a middle person in relation to a landlord and a tenant relationship, the body corporate does have a role to play. And mate, you probably recall the first version of this bill appeared before COVID, which seems forever ago. And to me, what they've produced now is something that's been watered down substantially. But I remember at the time of that first bill, it was almost as if who produced the bill for the tenancy bill is Department of Housing and Public Works.
Yeah.
They produced that without any reference at all to what goes on in Strata, and there's a whole bunch of us looking at it going, this is going to be the worst thing ever in terms of disputes. So it hasn't, this first version hasn't got that, and certainly, there's a bunch of changes that apply to every tenancy in Queensland, but we're not talking about those. It's just how these things affect Strata.
That's right.
So, yeah.
Yeah, so look, we'll go back to, as I say, operational right now are the reforms about domestic and family violence. And the one which impacts or has a relationship to Strata is that if somebody is needing to escape or prevent domestic and family violence, they're able to change locks without necessarily getting pre-approval for that. They must give keys and access devices, such as a fob, I guess, to the managing agent or landlord. Why is that an issue for Strata, Frank?
Because quite often locks, particularly in building format plans, are a piece of common property. And I suppose you'd even go even further and say from a QFES and fire safety perspective, it's all about being able to access doors without there being locks from the inside that can't be opened by master keys and all that sort of stuff. So even there's another little interplay that hasn't quite been taken into account, but that's certainly the case now. That's the legal position. So, the new access devices or otherwise need to be given to the landlord or the managing agent as soon as practicable, which doesn't mean the next day. But here we are.
That's right. And so, Frank, in addition to that, so that's one thing that is now operational. One thing that's not yet operational, but which will be at a date to be fixed, is in relation to pets. So you talked about how this bill has been watered down over time. When it first happened, I think it's fair to say that the bill was pretty gung-ho about the right of a tenant to keep a pet. And in fact, it was pretty much black and white, wasn't it, Frank?
It was, yeah. No, it's sort of watered down to a degree, but still, so the current regime, who knows how long that'll last, means that landlords, even, and when you look at a Form 18 lease, there's a consent form there. The landlord agrees or not agrees to the keeping of pets. So at the moment, it's at the absolute discretion of the landlord about whether they want a tenant to keep a pet. The way the bill changes that is that tenants are going to have the right to keep pets after they give notice to the landlord that they're going to keep one. And unless the landlord goes and makes an application for an order that the pet should not be kept in the lot and expresses the reasons for doing so. So I think it's pretty clear from the bill that a reason for doing so is not that I don't like pets. I don't want pets in my unit. So it's unless there's a really, really good reason for that to be the case, pets are going to be approved. And I suppose then the interplay with that is always, as we know, mate, body corporates are almost a parallel process. So we're going to have, inevitably, a raft of confusion where a tenant gives their notice to their landlord and says, you beauty, I've done what I need to do in relation to pets, and moves in and brings the dog, and then they gets a knock on the door from someone saying, mate, don't think you got approval for that. And it's like, well, what's the body corporate? So that educative piece, and certainly for real estate agents and resident managers who are involved in this, making sure that there's a parallel application to the body corporate, because certainly we still...
And a timely one too, Frank.
Yeah.
I think that's the important thing. Like if
Yeah.
the fact that the market's so tight at the moment, I mean, we hear stories all the time about properties that go the instant they're listed on the websites. So if that's the case, you can bet that nobody is taking the time to research pet bylaws or anything like that. And so, of course, the tenant comes along and is very happy and relieved that they've found a property and has maybe assumed or maybe been told by the agent, yeah, sure, this is pet friendly, it's all good, it's all good. And of course, they rock up to move in and there are restrictions or indeed prohibitions on animals. That's a problem. It's a big problem at that point, because really the only option left for the tenant then is to go to my former office and seek some fairly urgent relief. Even that may be too late at that point. So that is an example of where that interplay is going to be very difficult moving forward. Now, I stress those pet reforms are not enforced just yet, but they will be in the not too distant future. But it highlights, doesn't it, Frank, that kind of uneasy relationship and tension between body corporate and residential tenancies legislation. Let's get one thing straight from the get-go. Body corporate legislation refers to a tenant as an occupier. Now, there's no explicit definition of that, is there?
No, it doesn't say you've got to be there for 2 months or 3 weeks or 6 months or whatever it might be in terms of when you are one. And I think probably the example I've always used for clients in years gone by is really if it's where you're living, then you're more than likely an occupier. So it's not quite necessarily, into that goes where your post goes, where your toothbrush is, I suppose, is an old classic, isn't it? Where shoes go under the bed, who's on electricity bills and all that sort of thing. And there's a newsletter there which we'll put up that we wrote about visitor parking in Strata, because visitor parking, for whatever reason, has become the issue du jour we're getting at the moment, lots of it. So that's one where adjudicators consider the differences between occupiers and visitors and when the line gets crossed. And yes, it can be a little bit grey, but if you're living there full time, clearly you are, but it sort of gets a little bit greyer the less full time you are. But doesn't automatically make you there. But I suppose what we'd say is the legislation specifically reference occupiers, so almost pull out the Webster's dictionary.
So we're going to continue to refer to occupiers for the balance of the webinar, just to be technically correct. But I think, Frank, you've hit upon a really good point there, that what actually is an occupier is not, like pretty much everything in body corporate world, is not cut and dried. It's dependent upon circumstances. We've got a bunch of questions coming through. Thanks, everyone. We will get to those as we go along, but I just want to keep rolling along for a little bit longer if we can. So the Body Corporate and Community Management Act is pretty clear that when it comes to bylaws, there is no difference between an owner or an occupier. And in fact, Frank, the legislation makes plain there is to be no discrimination. It's the only time that word's mentioned.
Yes, that magic word, section 180, head straight there. So very specific. You cannot have different bylaws or bylaws that apply differently to different types of occupiers. So owners can use the pool after 6 p.m. All tenants have to be out by 5. Not valid.
Yeah. So what's good for the goose is good for the gander is your rule of thumb when it comes to owners and occupiers and bylaws. And I know that you and I, Frank, we've certainly heard of instances where a committee or a body corporate tries to make an occupier have less access to common property and things like that. I've heard those stories before. It's a no-no. It's a big no-no. And I know that some owners would not be pleased about that. And they'd ask the question, well, why should an occupier who doesn't pay any levies have the same right of access and the same right of usage of the pool, the spa, the sauna, the car park as I do?
And I think you'd go and look at it and say, well, the person who owns the property is paying levies, and in effect, they've parted with their right of possession to that property in exchange for rent paid by a tenant, which is the tenant's effective contribution towards those levies. So that's that equality element. So you just cannot do it. See it happen all the time. You cannot do it. Not all the time. We've found that occasionally.
No, that's right, Frank. And I think the other point to make there is that if someone's an occupier, and particularly if they're a long-term occupier, they're as much a part of the scheme as an owner. In fact, I'd say many cases, the occupier would actually be far more engaged with what's going on at the scheme than the owner would. If you think about an owner who's perhaps based interstate, uses the lot purely as an investment, never returns a voting paper, never puts their hand up to be on the committee, doesn't do anything other than maybe pay their levies, or maybe they don't even do that. And then you've got a tenant occupier, who's actually doing stuff at the scheme. I'll give you an example from my own experience. So I am an occupier in a community title scheme. I put out the wheelie bins every week. I also get them in most days, most times as well. Although lately, I've got to say, my fellow occupiers have been doing a much better job of sharing around that responsibility. The point being, there's no obligation on me to do that. In fact, I technically shouldn't be doing that if you want to make a big argument about it, but I take the view that I am part of it, and I've been part of this particular scheme for several years. So why wouldn't I contribute to it? Because otherwise I'm going to have a bunch of smelly bins sitting in the recess. No one wants that.
And I suppose then that leads to what New South Wales has sort of got to now, and what Queensland asked about. Should occupiers who aren't owners have some ability to have a say in the affairs of the body corporate?
So we've just put a link up there on screen about how an occupier is part of a committee in New South Wales. So it's in schemes where at least half the lots are tenanted. The tenant can nominate a tenant representative to the committee. They can attend the meeting. They're entitled to a copy of the agenda, but they don't have any voting rights, and they don't count for the purposes of quorum, and can also be asked to leave if financial issues are discussed, which is an interesting one, isn't it? I'm not sure why that distinction gets made and others wouldn't.
People getting sensitive about finances, but again, we're back to what we're talking about, access to body corporate records. A tenant's absolutely an interested person, so they'd be entitled in Queensland at least to go and get copies of all the financials if they felt like it. So degree of privacy that really doesn't exist. But anyway, so that's interesting in terms of New South Wales, where they've created that specific right for tenants to have a say. And I suppose I'd look at that.
Frank has departed the building for some reason. We might have a bit of a technical issue there. I will plough on, and hopefully Frank will rejoin shortly. I think Frank, what was getting at there, be keen for everybody watching this to let me know. Do you think there's any situation in which a tenant could be part of a body corporate committee in Queensland? It doesn't happen at the moment. It may happen in the future, who knows? But I would be really keen to hear what people thought about that kind of thing.
And I'm back.
Frank's back, and we've also switched sides. This is just bizarre.
It just stopped.
Yeah.
Like, oh, righto.
Well, while you're getting your bearings, Frank, we might pause and try to address a few of these questions. I just put it to everybody, that could a tenant be part of a committee in Queensland? What do people think of that? So I'd be keen to get people's thoughts on that. If it doesn't happen at the moment, but if government went down that path, what would people think about that? Let's try a few questions. Peter, as always, thank you. I'm not sure if Frank has given exercise equipment back yet. I'll say no, probably not. Matthew, you'll now notice I'm back on the other side of the screen, but yes, that's right. Wayne, thanks for tuning in. So if you want to keep an elephant in my rental, that's now okay. The owner can't say no. Body corporate must agree. No, that's not right, Wayne. The owner can say no under certain circumstances, but the point Frank was making is that it's difficult to say no. The criteria for saying no is quite limited.
It's not going to be that you don't feel like it. So to me, the unit's not appropriate for the keeping of an elephant probably would be a valid reason for saying no. But if you're talking about a small, white, fluffy dog, then probably it's going to be really, really hard to refuse it.
Yeah. Peter, again, where the landlord says yes to the pet and body corporate says no, does the body corporate take action against the landlord or the tenant? No, it's the tenant would have to enliven their rights there, Peter, under that one. So we will get to, I can't remember if we discussed it or not, but an occupier is able to lodge an application with my former office for dispute resolution. Viv, I believe if the body corporates say no, the tenant can apply the BCCM. That's right. Ian, thank you, Ian. What's wrong with using the word resident rather than occupier? Residents give the inference as a group of people living under the same rules and regulations. I don't disagree with you.
Same page. Word nerds agree, and it's probably part of this owners versus tenants thing is different terminology implies sort of different status. Residence actually is a far more, you'd sort of collaborative term. Makes a heap of sense.
That may yet get on the agenda for when the Act gets reformed in Queensland. Sometimes what happens is that terminology gets cleaned up along the way. That could be one of the things that does happen. Wayne thinks that there should be ability of occupiers to be part of the committee to have an interest in the building. Thanks, Wayne. Liz, if a tenant is given limited power of attorney from their owner, can't they be then elected to the committee? Yes, they can.
Absolutely.
Mandy, a tenant on the committee could be good as they bring professional knowledge. Yep. They're not financially invested, so have a more objective view. Reasonable. David, thanks, David. Tenants could be excellent committee members and have the right experience. Don't see why not. Maybe after a minimum occupancy period, such as 12 months. Interesting.
Maybe. I suppose maybe even subject to having a lease of that long, because I mean, a committee occupation is a 12-month period as a rule, isn't it? So if you've only got a 6-month lease, you might only be there for half the time. Maybe the right to participate in the affairs for the whole period would make some sense too, if the government's going to go there and make that a condition.
That's a good point. Thanks for that, David. Mark, thank you. As an agent, will it be illegal to ask if applicants have pets when they apply for a rental property? If this is the case, is it then legal to ask if they have a pet on the body corporate's behalf? Not sure I can't really comment from the agent side of things because that gets more into property agent issues.
But I'd be saying that's a legitimate question to ask, in the same of how many people are going to be living in the premises? How many cars do you have? Do you want to keep a pet? Because to me, I suppose your job as an agent is to make sure that you're tenanting the property with people that are appropriate to tenant it. So if they do have pets and they want to keep pets, then that's relevant in terms of going to the landlord to say, hey, here's this deal, and also saying to them, you've also got to make application of the body corporate and here's how it works.
Yeah, I suppose, Mark, the other point I'd add is that it would become very quickly apparent if somebody had a pet and it was not approved. That happens routinely. Graham, is cleaning after a pet a sufficient requirement if the owner is affected by animals, such as asthma or allergic reaction? I think it is actually one of the criteria, or it could be. Yeah,
and I think if you follow the BCCM cases, and so for those of you that are interested, Chris and I suppose, we've got 80 of these webinars on our webpage now, believe it or not. We've done a couple on pets, and particularly about bodies corporates' reasons for refusing pets. You think there's probably going to be some parallels when the pet provisions of the residential tenancies legislation come in, there's probably going to be some parallels.
Yeah. All right. Keep rolling in with your questions, everyone, but we're going to quickly revert back to our prepared words because we are fast coming to the end. We want to touch upon bylaws, and we'll have to rip through this relatively quickly. So when it comes to bylaws, an occupier has a right to have bylaws enforced. But, of course, the reverse is true. The occupier has the right to have bylaws enforced against them. The important point to remember here is that the body corporate enforces the bylaws. So the body corporate, through its committee, has a direct relationship with the occupier. It's not up to the landlord. It's not up to the owner of the lot necessarily to enforce bylaws. It's up to the committee. And that, Frank, is a big misconception, isn't it?
It is, absolutely. And that's where sometimes in a resident manager context, there's different hats. The manager's acting as landlord for a lot owner, and whether they enforce breaches of bylaws against their tenant under the lease is completely independent of whether the body corporate wants to do something in relation to the enforcement of the bylaws as a body corporate. But it's quite often for resident managers to get caught in the mix. But I suppose, Chris, as we always say, with rights comes responsibilities, doesn't it?
That's right. There's no reason why the landlord can't be involved in the process. And in fact, they should be involved in the process. Like if you've got an occupier who's causing issues in the building, if the owner doesn't already know via their real estate agent, and that's a separate problem if they don't. But if they don't, it's quite appropriate for the committee to get in touch with that owner and say, hey, did you know that all of this is going on? That's actually probably the far better way of getting the landlord involved in the situation. And this then leads us to one of the big kind of interactions between tenants and strata, which is the body corporate role. And it's also a big mystery and a big unknown. So any lease of more than 6 months must be recorded on the body corporate role, and then includes any details of the tenants, as well as the details of the managing agent, and that is whether it's 6 months or not. And there are financial penalties which apply for that not being done. That's one that's not very well known, is it, Frank?
No.
I think I've been at seminars where that's been mentioned, and there's been a lot of, how would you call it, panicked looks on the faces of real estate agents.
Widened eyes, really?
Yes.
Yeah.
Yep.
Yep.
Yeah. So that's the way. That's the most direct way, I think, that that body corporate interacts with an occupier. That there is that direct relationship which says at the 6 month mark, you are more or less considered on the same footing as an owner. Do you agree, Frank?
Yeah, absolutely. And I suppose that maybe that's back to that, the residents bit and being on committee at some stage. It's a really interesting conversation. But yeah, and it's there. And again, the same as there's no Privacy Act in the sense of information, the tenant's details, email address, phone call, all that sort of stuff really gets towards that community element where the whole of the body corporate can be in contact, or the whole of all of the occupiers, all of the residents can be in contact with each other via that role. That's what it's there for.
That's right. And so the point that comes out of that is, if that's news to you watching this, you really should be getting onto it, because the up-to-date role is, I tend to think that's the number one thing that a body corporate needs to ensure it effectively runs itself. It's by that means by which everything else kind of follows after that point. And if you're not sure how to go about it, the first place you start is with your owner, or you go and knock on the door, basic stuff like that. Yeah. But to be fair, Frank, it can be very difficult getting those details, can't it?
Absolutely. And I mean, it just comes back to everyone running their own little race. And I mean, one of the reasons we're doing these things is to probably try to educate people about what should happen.
Yeah, that's right. Just very quickly, because we want to wrap up with our usual best practice tips, but very quickly, another point of difference, if you like, between body corporate and tenancy legislation is the right to enter a lot. A body corporate has an express right to enter the lot, and that's separate from the landlord or the agent's right to enter the lot. So again, I'm an occupier. I know that I had my real estate agent over here 2 weeks ago doing an inspection, and they sent me a notice, they sent me a text, they sent me a reminder the day before, they specified a time frame, they specified a date, all the rest of it. Not the same for a body corporate, Frank.
No, body corporate can access a lot for proper purposes on 7 days notice, or under lesser time periods in the event of an emergency. So, and that is where coming in. So, and occasionally this sometimes happen where bodies corporates mistakenly use master keys to access lots without giving the requisite notice. And usually the dispute happens when they access a tenant's or an occupier's lot who isn't an owner, who wasn't aware about what was going on. And again, that's back to that role and that communication piece. But, so under a tenancy agreement, tenants are entitled to quiet enjoyment and exclusive possession. Those words are not used in the BCCM legislation when it comes to accessing a lot for body corporate purposes, to access infrastructure, to check things out, to do all the things that a body corporate's got to do at law. That does get confused a lot.
There's no right of refusal for an occupier for the body corporate properly entering the lot. Yeah, that doesn't apply. All right, best practice, because we really are running out of time. So our best practice today, it's give and take. So occupiers have as much of a role as anybody else, but it works both ways. Rights and obligations need to be properly understood. Number 2, Frank, unsurprisingly, communication is key.
Yet again, always the way with these things. And to me, that's part of that community element. If you want to get the best out of everyone, it's certainly not going towards that us and them mentality, owners versus tenants. It is, we're all living here together. Leave aside the legal status. I want to go back to the lawyer thing in terms of the basis of which you're there. We're all here together. How is this going to work? And that engagement piece where you're not firing off emails at midnight, getting unhappy about things, which is a hell of a lot harder to do when you actually know someone face to face.
Which leads us to point 3, which is that a long-term occupier can be of a huge benefit to body corporate. They can be effectively eyes and ears, especially in a scheme where there aren't that many owner-occupiers. A long-term occupier who has some, we've talked about the engagement of occupiers today, depending upon how long they might be there, for example, they can add a lot of value to the scheme. So it's wise to try and cultivate. Couple more comments there have just come through. Wayne, thanks for tuning in. That's not really a question I think that we can answer, except to say that my understanding is that if you're an agent, your responsibility is to your vendor at all times. So you've got to think about it, but yeah, that's not really much more that we can.
And then acting on those instructions is acting on those instructions, provided they're not discriminatory. You know, so I don't want a woman as a tenant is going to be discriminatory. Apart from that, if it's you know, the tenant you want might be, I want $800 a week and the unit's only worth 400. Okay, well, you'll be waiting a long time, mate, but there you go. There's your instructions.
There you go. And Peter, thanks again for your further comments, and Ian as well. Gosh, there's been a lot of commentary on this topic. Thank you, everyone. Obviously, this remains a topic of some considerable interest, and I think what it highlights is just that lack of understanding and lack of that confusion between strata legislation and tenancy legislation. We can expect to see more of it over the next probably 2 years, I'd suggest. There'll be much more of it to come. Jan, one quick question there at the end. Once pet legislation comes in, can a pet bond be charged?
I don't think so.
Yeah,
I don't think so. I think it's probably the same bond 4 weeks, away you go.
Yeah, but don't quote us on that. I reckon have a chat with the RTA on that one, Jan. Thanks, everybody, for tuning in. Great discussion today. Next week, Frank, our final webinar for 2021. And we're going to reflect upon the year that was, and perhaps with a bit of an eye towards the future as well.
Yeah.
You've got to look back in order to look forward.
Yep, it's been another big 12 months, and actually at the moment I'm okay with the days of the week, but I'm struggling with which year it is. So when we tip into 2022, I'm still going to be lurking around in the 20s and 21s somewhere. So it's been fairly hectic, but yeah, it'll be interesting. Because I suppose it's that step back, what happened? And there's been a lot of it.
It's important to reflect. There's probably plenty of it that we've forgotten, and that you might have forgotten as well. Bev, very quick question at the end. Who is liable for penalty if roll isn't up to date? The person who is meant to provide the information is liable for that penalty. And while we're at it, one more final quick question. David, how can the body corporate enter a lot if the lot is not common property? They have an express legislative right to do so under certain circumstances, David. Yep.
Story.
Thanks, everybody.
See you next week.